For 14 years, he served on the United States Court of Appeals for the First Circuit, based in Boston. In 1994, President Bill Clinton nominated him to be the 108th Justice in the history of the Supreme Court of the United States. And we are delighted to have him here today. Please welcome Justice Breyer. I know you're used to people standing up when you walk in.
I trip over them,
but they don't always stand up for our guests.
That's very nice. Thank you.
Welcome to the New Yorker Festival.
Thank you very much.
So what'd you do last night?
He knows what I did. We had a dinner. We had a welcome dinner for Justice Alito. We have a welcome dinner when everyone comes and when anyone leaves.
The court does get along
very well. Personally, we get along well. I've often said in the conference room, and we've had some difficult disagreements, as you know, but I've never heard a voice raised in anger in that conference room. Never. Not in 12 years. And I've never heard one member of the court say something insulting or slighting, not even as a joke, about another member. It's very professional. We have our discussion, and after we have lunch or whatever. And Bill Rehnquist actually said when he was chief, I remember on one occasion we'd had two very difficult cases. And they're not all. I mean, we're often unanimous. We're unanimous 40% or so of the time. We're 5-4 about, I guess, 20 to 25%. And it's not always the same 5-4 by any means. I mean, it shifts around. But in that particular occasion, it was as I won't predict, but you might have predicted. But it was slightly different. There were shifts, and so it was 5-4, 4-5, whatever you want. But afterwards, I said to the chief, I said, you know, it's so interesting. We're having lunch, and just a few minutes ago, there in each of those cases, 4 people. He said, I know. He said, in each of those cases, there were 4 people or 5 who thought the other 4 or 5 were totally out of their minds. But the conference is professional. And I think Rehnquist really gets some credit for that. I suspect, though I can't prove it, but I suspect he came out of a time when he was chief where the court had not been getting on perfectly well individually all the time. And he wanted to be certain that they did. And this is my interpretation. And I think that one of the ways which helped a lot is in that conference, he had 2 rules. And the first rule was nobody speaks twice till everybody speaks once. I was junior, of course, and spoke less, so I agree that rule's in my benefit. But nonetheless, it helps a lot. People feel they've been heard. And the other rule is tomorrow is a new day. That is, this case does not depend on that case. You can have 5 people absolutely convinced that this is right, and then the next case comes along, and that's it. We're going to figure this out again. I'm not saying your views might not carry over, but there's no bargaining from case to case.
When I wrote about you for The New Yorker, I followed you to various speeches that you gave and talking to law school groups. And one thing you always said was, you know, I listed some of your academic credentials, but the one you always talked about was, well, I went to Lowell High School. That doesn't mean a lot to you, but it means a lot to me. And why did you say that? What is it about Lowell High School that sticks with you, and what is Lowell High School?
I sometimes have felt where there are very difficult open questions of constitutional law, for example. You know, the word liberty in the 14th Amendment does not explain itself. Even words that we think are clearer and more definite, like the First Amendment, Congress shall not abridge the freedom of speech. Well, the freedom of speech, the content of that, precisely, particularly at the edges, is not written directly into the Constitution. I mean, that's why I say often we want to look to the consequences. I don't mean you look to all the consequences of a decision, But I do mean you try to identify in the Constitution that value that underlies the First Amendment. Same then as now, freedom of speech. Same value, unreasonable searches. Same value, privacy. But then applying that today, just as you apply the Commerce Clause, people hadn't thought of the Internet. Well, they hadn't thought of a lot of things that was going to affect, perhaps that would affect freedom of speech one way or the other. So what I think often you're trying to do is you're trying to look to see what were the values then and what are the facts and circumstances now, and how do they apply now. And that's why I say Lowell High School. Why? Because a person, while I think you can pretty much escape politics, are you a Democrat or a Republican? Do you think this senator is popular or that senator is popular? You can and you should escape politics in that sense of what politicians mean by politics. How many votes do I have? Oh, we escape that. And you can escape ideology. Are you a Marxist, Maoist struggle sessioner or a Adam Smith free enterpriser till the end? I mean, that's sort of, we don't have to get into that. But I think it's hard to escape your background. I think it's hard to escape your adolescence. I think it's hard to escape your family. I think it's hard to escape who you are as a person after X number of years. I have quite a few under my belt there. But and that's what I mean. Sometimes I think, well, maybe Lowell High School, San Francisco, 1950s, and that helps explain me to myself.
There must have been something in the water at the Breyer household. Your brother is a federal district judge in San Francisco, Chuck Breyer. So there must have been something about the Breyer household to breed all these judges. Your dad was a lawyer for the San Francisco school system.
We didn't sit around with a gavel all the time.
No.
I think, my dad worked for the San Francisco School Department. He was the lawyer. I have his watch here, which I've had. It says Irving Breyer, 1932, 1972, SFUSD, that's San Francisco Unified School District. And my mother was active in civic affairs. She, like the United Nations Association, she worked in some political campaigns. So we lived in the city, and I would say that I grew up thinking that local government was important, and so did my parents think that's what they thought, and that you ought to participate in the community.
You then clerked on the Supreme Court.
Not immediately. I went to college.
No, college, right. You were a good student at Lowell High School, but not that good. Right? What were your impressions of the court as a law clerk?
I think the time had a lot to do with it. I clerked for Arthur Goldberg in the 1964 term, 1964-65. I think at that time, my impression, and I think the other clerks, it was a court with a mission. And the mission grew out of the Brown versus Board of Education decision. I mean, Brown versus Board, I think to me and probably to many others, is a reading of the Constitution that's virtually literal. It says, a state shall not deprive any person of equal protection of the laws. Well, at that you had to look around, and there were states all over the place that were depriving large numbers of people of sometimes no protection of the law, and certainly not equal protection. I showed that sometimes to some of my students. I've used that in a lecture because I got a picture of the black school in the South and the white school and said, well, one's a shack and the other looks like a school building, and say, there it is, equal protection of the law. But the problem for the court was really, I think, the problem of my next slide, which I used in this lecture, which I got a picture of the Ku Klux Klan. And people really violently opposed to what the court had done. I can remember that, the impeach Earl Warren signs. And the court was not receiving much assistance. Congress didn't do very much. I mean, eventually they did. They began to in '64 with the Public Accommodations Act. But They hadn't done a lot, and there was, it isn't as if there was one rule saying schools will be segregated and you just erase that rule. It was a system of life, and it permeated the law in hundreds of different ways. It was a very, very complex system of law that supported this institutional segregation. And I felt that the Warren Court saw as its primary effort to see that that equal protection of the law, which in Brown had been held is part of the Constitution, would become meaningful and would actually work in the sense of dismantling this whole complex a set of rules and legal regulations and so forth that supported segregation. So I think we had the sit-in cases that year. There were others that came up, and then other civil liberties cases grew up around that. But I think that was at the heart of it. That was my impression of the court then. We had two law clerks. Now we have 4. But it was a united court in respect to the need to make the law clear throughout the country that there is no more legal racial segregation, period.
The justices are always invited to the State of the Union address, but attendance is spotty. In fact, there is only one justice who always attends the State of the Union. Who is that? You. Why do you always?
It's not a hardship. Why do you? It's sort of like a hardship.
Sometimes it's only you.
Yeah,
it's been only you. Why do you go to the State of the Union every year?
Well, I think it's very interesting, and I also perhaps think it's important. We are part of the government of the United States, and this is something none of us knows about, actually, and the younger people have a better idea. I think, as we all read, we who are a little older, that the younger members of our society get more and more information from television. It's not exactly a revelation that I found here, but so they'll look at the image and they see who's there. Well, the judiciary is part of the government of the United States. Indeed, I think it's important and really quite sad that not enough of the people understand how we're part of the United States. That Congress is the elected branch from the people directly, as is the president, and the job of that unelected branch, namely the judiciary, is not to say what's wise or intelligent or good or anything else like that. That's, in a democracy, the decision of the president, and it's the decision of Congress. But it is to say, when a decision on their part or elsewhere goes off the constitutional rails. Now, the Constitution sets boundaries or rails that are awfully broad. It's a Constitution that primarily tries to create democratic institutions of government so that people themselves can decide what kind of rules they want for society. But it also protects certain basic fundamental rights. It divides power so that no one in government can become too powerful. We have state, federal, and 3 branches. It assures a certain degree of equality, and it insists upon a rule of law. So there we are. We're sort of the champions of the rails, if you like, or we're there to guard the frontier. I put it that way sometimes, as if there's a constitutional frontier, and in between, there's room for, indeed it is expected that, citizens will make their own decisions through their elected representatives. Well, life sometimes at the frontier is not so easy. And we have some pretty tough cases. Is abortion on this side or that side? And what about prayer in schools? And what about, you think they're not controversial? They are. People feel very strongly. And we may not be right. I don't know. We're 9 human beings. We're not always right, and we're divided often. It's very hard to say that there's some guarantee that we're right, and it's pretty hard not to understand that people get angry at us and think we're wrong. At least half the country, one way or the other, in some of these things. All right, but what we're doing is still at the boundary. And in between, it's participatory, democratic, and necessary that people participate in making those decisions. Now, that vision is what I think the Constitution says. And I know that it takes at least 5 minutes to get it across. And really, it takes a lot more teaching than that, and that's what we have 12th grade civics for. That's a long way of saying, I want people who tune in and look at that State of the Union to say, yes, I see, there's the President, there is Congress, and there are some people, too, along with the Joint Chiefs of Staff and various others, but there are some people, too, who are there in robes and they're judges, and they have a role, not the predominant role, but a role to play in the application of the Constitution. And I'll feel very lucky if those who don't know exactly what that role is say, I wonder what it is. And maybe they'll find out. And that will be a victory. But that's an ideal. But that's to give you a rough sort of understanding of why I want to be there.
Could you talk about why this book, Active Liberty, a wonderful book that Justice Breyer wrote last year, is called Active Liberty. It is not a title that explains itself. What do you mean by active liberty? Because I think it relates to your view of the political process.
It's very much what I was trying to describe, that I think that the point of the Constitution, the basic point, is this democratic point. You know, Sandra O'Connor and Tony Kennedy and I were discussing this with Vartan Gregorian, who used to be the head of this library. And he was there with people at the Annenberg Foundation, Mrs. Annenberg, and he wants students across the country to learn this, to know it. What we used to call 12th grade civics. And the point that people were listing what's the most important parts of the Constitution. We had free speech. We had surveys that lawyers had answered, polls, free speech, equality, etc. We all said, no, those are important, but not the most important. The most important part is this democratic part, where people choose for themselves. Now, what I really want to say here, and why I went on to talk to the student groups, which I like to do, is I want to say this is not a book about activists. This is a slogan which they had. It's not a book about activist judges. It's a book about activist citizens. You don't need the activist judges. You do need the activist citizen. I want to say that I can't tell you in the 10th grade, 11th grade, 12th grade, college, I can't tell you that you ought to participate in community affairs. But I can tell you that this Constitution, in my opinion, and I work with it every day, that won't work itself. The Constitution won't work unless you do participate. Because it foresees a nation of citizens who do. That's my sort of what you call stump speech. Is that right? I want to tell them, I don't mind if you participate on the board of the school district or on a museum or in some community housing project or in a political campaign or voting or any other way you want. But please, if you don't, that document that I work with is going to fall apart.
One way that people are participating in the political system is attacking judges lately. And in Congress, this has been bigger in recent years than it had been. In the Terry Schiavo case, you've had a proposal for an inspector general of judges, and you and Justice O'Connor last week hosted a conference at Georgetown where, in keeping with her role as a retired justice, no longer bound by precisely the same strictures, she's been saying, this is really bad. I'm really worried about this. What is your view about the threats to judicial independence?
But she doesn't say it's bad for people to get up and give speeches about what idiots judges are or how wrong they are or how foolish what they do is. That's fine. I mean, it is a country where people can criticize. They have every right to do it and should do it if that's what they think. But the object of the conference is to try to make that criticism somewhat more informed. For example, if you decide, as I think in one state they're having on the ballot, proposition called jail for judges or something. Where they,
South Dakota.
Yeah, or they want to put the judges in jail, I guess, if their decisions are wrong, or at least they want to. That's a thought. Or you can have judges elected every 2 years. Some people want to do that and so forth. But you can't have it both ways. And what that conference is there to say is that an independent judge is a judge who will not be moved by the fact that this person in front of me is the least popular person in the United States. I think you want the judge to say, so what? The question is, what are that person's legal rights? And who is right or wrong under the law in this case? And if you put a judge up for election every year or so, are you sure that's what you're going to get? Now, that much I think you can ask. So when I talked to people at that conference, I told them about something that made an impression on me, because before I was on the court, I think in the early 1990s, I was lucky enough to be a member of a delegation that went to Russia. And we went to a meeting of judges in Russia. And then they began to talk about telephone justice. Well, I said, what's telephone justice? Telephone justice was when the party boss telephoned the judge and told him how to decide the case. Talking about it, which I gather they didn't normally do. And one said, well, will that stop? And he said, I don't know. He said, well, why did we do that? Why did we do that? And the answer is, it's obvious. Why did they do that? I said, what are you talking about? You need a place to live. You need food for the family. You want your child to go to school. And who controls all that? Who controls it? And that's why. And then they began to ask me, well, what about the United States? Do you have telephone justice? I said, no. They said, well, who appointed you? I said, President Carter. And they said, well, why did he appoint you? I said, it's quite possible the Court of Appeals, Senator Kennedy probably recommended me. And he said, well, suppose Senator Kennedy calls you. Suppose President Carter calls you. What will you do? I said, but they won't call. So then I was getting skeptical looks. So I said, I see. You think that even if they would call, I would say they wouldn't. They said, yeah, that's just what we think. So then I said, but it just doesn't make any sense. I mean, if they did, why would they want to put themselves so at risk? They could end up in jail. I mean, it would be terrible. It would be a scandal of unbelievable proportions. And I went on and became so sort of wrapped up in this that they began to believe me. But what I took out of that, and is that this independence, which to me, of course, and I think to you, I think to everyone, is so important. It's actually not just words on paper. I understand that the federal Constitution says that we serve for life. It says good behavior. And that we have a pay that cannot be, it says compensation cannot be diminished, though of course they don't have to keep us up with inflation, which they don't. But but it isn't really that. I mean, that may be help, but it's a state of mind. It's a state of mind. And Tony Kennedy, my colleague, said this very well when we had some Russian judges there. And he said, this was under the new regimes, and they're trying, and they have a hard time. He said, we can understand, but look, ultimately when you are a judge and you're deciding some of these very difficult matters, if it's two individuals, not a big issue, they know. There's a record in that case. And who knows if you're being really true to the facts in that record? You know. They may know, but they won't be believed, because everybody thinks they're partisan in their own causes. And when you have a big case, and you're trying to figure out the open meaning of the question, are you being true to yourself as a judge or not? Who really knows? Only you. Because there is a loneliness to this that other judges can't tell you what to do. No one can. That the judges can understand how you feel. That's as close as we can get. And what he's trying to do in saying that is to communicate something about the state of mind, which I call the independence of the judge, which in this country, I think pretty much we have. And my goodness, it takes a long time to develop it. We're very lucky.
A lot of people are worried about the Supreme Court. A lot of people think the court is going to get too conservative, that Roe v. Wade is going to be overturned, that affirmative action is going to be outlawed, that executive power is going to be expanded, and they're worried. Should they be?
You don't know how other people, who's going to think what. I can tell you this from my own experience. Whatever your background, when you put on the judicial robe of a federal judge, there we are. We're judges now. You're a man or a woman who came from different places with different views. It doesn't mean your fundamental outlook of the world will change. It doesn't mean that your ideas about what law is like or how it relates to people and so forth, that won't necessarily change. But the politics does, I think, go away. And there's nothing really left for you to do but decide the case as best you can. I have a lot of confidence in the reasoning process. I have a lot of confidence, but I also know people can see things differently. Now, that's the most I can say. I can't allay your worries by telling you how every case is going to come out. I don't know. And indeed, when I hear people say, are you going to decide the case this way or that way, I think when I first was appointed, when it was me, will you decide this way or that way? I say the only truthful answer is I'm not sure. Of course, you don't go to the court, and I said you don't go to the court with some kind of agenda. That's what I said in my confirmation process. And I can't imagine how a person could have thought all these things out in advance. I mean, just even questions were, and that's why judges often don't give opinions on hot topical issues. Not that there's an ethical rule against it, though there is. But really that reflects a reality that often when you see briefing and you see it worked out thoroughly and you hear the arguments, it doesn't quite appear to you the same as it appeared to you when you read it in the 2 paragraphs in the newspaper. And that's a truthful thing. That isn't, there's just so many times when I thought it might be this or that, and then, no, you read through it. I mean, the old joke is sort of true. You know, you read the blue brief or the petitioner's brief, and you say, that's right. And you read the red brief, the respondent's brief. Yep, that's right. You say, well, they can't both be right. Yeah, that's right.
You were on the court for 11 years with the same 9 justices. It was the longest time the same 9 justices have served together in the history of the court. You've had 2 new colleagues join in less than a year. How is the court different?
Changes. It's different. The dynamic will be a little different. It takes time to see. I don't think the personal relation will get worse. I think we'll get on well. I think we did get on well, and there's every indication that it personally will continue to get on well. How people react to each other's arguments and how they deal in the conference, there may be a little bit more discussion. I think maybe not. We'll see. So there's a difference in the personal dynamic, professionally speaking. But we'll get on.
Okay. Can we bring up the lights a little bit and invite questions?
Justice Breyer, it is just such a thrill to have you here. I'm a law student, and I'm sure you remember when you're in law school, justices, you're our rock stars. And we very often wonder about what kind of influences, maybe even popular culture, come into your life. There's a generation gap, and also you're busy thinking about the big questions. So I wonder, do you have time? Do you read The New Yorker? Have you ever been in a chat room?
Yes, I have. I admit I've read The New Yorker.
Have you ever been in a chat room? Have you ever seen The Simpsons?
Have I seen The Simpsons?
The Simpsons.
Have I ever seen The Simpsons? Yes.
Okay. And I'm also especially curious, you are such a gifted person. If you hadn't gone into law, what would you be doing now? What would your second life
On the bread
have been?
line. I'd be on the bread line. I don't know. I've always, this is true. I probably, we were much less questioning in those ancient days. And my father was a lawyer, and I thought law would be very interesting. And the one piece of advice he gave me before he died was, stay on the payroll.
But do you and Justice Thomas, as I understand it, are the only sort of technologically savvy, really, members of the court. I mean, you email and
Justice Stevens uses an email. I think Justice Stevens uses the computer and back and forth very easily. I think several of us do.
This is the New Yorker Festival. I want to ask you a question about writing. Could you give some examples of judges who are really great writers, past or present, and why?
Good question.
That's a very good question. Cardoza is a great writer. Cardoza is a great writer because he is able to use the metaphor without it going too far. I mean, the cry of distress is the call to rescue. In a case about the duty of a lifeguard or someone else to go out and you hear and save the person. Is there a duty? Isn't there? And he was able to use these metaphors in a way that was both communicated and also instructed in the law, which is really not so easy to do. It's not that hard, though not easy, to think of a colorful metaphor. But the colorful metaphor is risky if it misleads. So better to be dull, as I am afraid I sometimes am, rather to be dull and to be accurate in writing a document, the words of which will influence or require conduct on the part of other people. Holmes was a great writer. Holmes had this unbelievable ability to compress in a single phrase, not just a metaphor. It isn't metaphorical necessarily, but a lot of meaning. There was a great case. I love this phrase from Holmes, and it's artistic, which suits this festival. There was a case in which the question was the power, I believe the state of New York, to regulate scalpers who were selling tickets at artistic events. And the test at that time as to whether the state could regulate was whether or not there was a public necessity. Whether or not there was a public interest, it was a public necessity, something like that. And I don't have it quite right. And he started out by saying, the majority had said, no, they can't do it because this kind of artistic thing is superfluous. They had said that, something like that. So he picked that up. And he says, we have not that great love of art that is the glory of France. But for some of us, the superfluous is the necessary.
As a gay American, I really am having a hard time seeing that reasoning is really being brought to bear on the question of whether old rules that are depriving gay people of having equal protection under the law are being analyzed under, whether they should be analyzed under a heightened level of scrutiny. You have, for example, the most recent New York Supreme Court case that denied the fight for the right of gay people to marry, based on a rationale for a law dating from the early 1900s.
A little fast.
Basically that it's better for children. There's a state policy to bring together, make sure that men and women who have children are married.
What you really would like to know, and you're trying to ask me something that you know perfectly well. I'm not going to be able to answer insofar as it goes to detailed rules and regulations. I can, though this won't help you too much. I can tell you quite an interesting problem I can talk about in that respect. And this is a general problem for, I think, a judge, particularly in our court. As you know, we decided a case called Lawrence v. Texas.
That's right.
And in Lawrence v. Texas, we struck down a statute in Texas involving sodomy, basically. And it had been enforced against homosexuals, and only rarely. only rarely, but never against heterosexuals, only homosexuals. We said that was unconstitutional. And and so we said it. That was the decision. It was 5-4, maybe 6-3 in that. 6-3 because there was the concurrence. That's right. And now, what's to me interesting as a judge, not just the result. I was in the majority. I thought that was the right result. But also, how do we write that case? To what extent do you, in fact, what kind of rhetoric to use? And that's something you should think about. I see in the court, which is such a terrific thing, is that I see people of all kinds, every minority in the world, every race, every religion, every point of view. They're there in that court to get things decided. That's America. And so I can decide, in a case like Lawrence, the minority deserves protection. That won't do enough for you because you think that's just a beginning. All right? I'm posing the problems here. How do you bring the majority along? How do you get other people to see? That's not just a legal problem. But it comes up because I know first and foremost it's my responsibility to be certain that these courts, with their protection of minorities, are accepted by the majority. They too may be minorities someday.
I'm a high school government teacher, and I would love nothing more than to be able to show my students the court in action. When do you think, when would we see the Supreme Court televised?
Good question.
There are very good arguments along the lines that you are implying that we should, because it would be educational. If people could have seen the hearing, the oral argument in the case I mentioned about the term limits, I think they would have seen people very serious about their work, and they would have seen how difficult some of these things are. It would have been a big plus for the legal system. You're probably less familiar with the arguments against it. And the arguments against it are, if we do it, it'll be in every courtroom in the country, including the criminal cases. We can't stop it. Once it's there, we're a symbol. And think of O.J. Simpson, okay? Mm-hmm. The other argument against it is that most of what we do is in writing. And 95% of it comes out, decisions come out of the briefs. The oral argument is really for us to ask questions. It's just an hour. And people won't understand what they do when they watch it. They read in the newspaper about what happened in the case. That's fine. But to watch it, that hour is not really going to explain what the court does very well. They'll think this small part's the whole thing. And then the other argument against it is that unlike a trial court, where the real question is who won and who lost, in an appeals court like ours, where we're deciding a rule of law, that rule of law is not going to just affect those two people in front of us. People relate to people. People relate to what they see. They look at the lawyer this side, that side of the clients, and they think who's good and who's bad. But our job is primarily to think how that interpretation will affect 300 million people who aren't in the room. And those are people who won't be seen. And those are people whom the newspaper, more likely than the press, visually, will tell them about. Now, we have some arguments one way which are very good. In my mind, the arguments the other way are also quite good. And I end up with a big question mark, a great unknown. Now, that doesn't mean we'll never do it. I think it does mean we'll go pretty slowly. I think it means we might begin with radio broadcasts. It might be you might want to see what happens, and maybe eventually we'll do it. But I'm not prepared to take a risk for an institution that means a lot to other people, of which I'm obliged to be certain isn't hurt. That's why you get among the 9 of us an attitude there that I'd call conservative with a small c. It doesn't mean we'll never change.
If I could just put in a plug for anyone who's in Washington, if you happen to be there at the court on the day of an argument, you should go. It's really a great thing to do. And the court, when I started going to the Supreme Court in the 80s, it was a very different experience to go to an argument because there were not many justices who asked questions. Now it's an extremely hot bench, as it's called, and the lawyers are often very good, and the justices are always right on top of things. And it's really, it's an educational and also entertaining experience. And the court has gotten a little looser in its slow-moving way. Transcripts are now available to the press the day of the argument.
And we've had radio broadcasts.
And there have been some on Bush v. Gore and some of the other big cases. The audio.
And the world hasn't come to an end.
No.
No, we've had the radio broadcasts. They've been fine.
Keep in mind, though, that Justice Souter said that cameras will come into the Supreme Court over his dead body. So there's.
He exaggerates.
Anyway, next question.
A judge on the Ninth Circuit Court of Appeals spoke about the process of making a decision, and he said that he tried his best to always rule honestly. And when I asked him what he meant by that, he said that there were times in conference where he had voted one way, but when he sat down to write the opinion, he found that it just wasn't right. And I wondered if you had had any cases like that where you sat down and realized you just couldn't write the way that you thought it was going to write.
Yes.
May I ask you what those cases were?
And then I've changed.
How often would you say?
No, it doesn't happen often. Rarely. I mean, very rarely, but it's happened on the Supreme Court.
How often would you say you've had your mind changed by the oral arguments?
I would say it's hard to say. If you say 5%, that's too low. It depends on what change is. If you mean actually switch directions, I go in thinking, look, the process, maybe you say a word about the process,
Please.
But I think it is. And I think it's not so different from people in other professions as well. I start, I'll read the opinion below in a case. The minute I look at the question in front of us and read the opinion, I already have a view. I have a view of who's likely to be right and who's likely to be wrong.
You read the opinion of that's being appealed from.
Yeah, correct. I'll read the question.
The judge's opinion.
I have a view. I read the opinion. I may not have the same view, but I have a view. I read the brief over here, the ones over there, the amicus briefs. I always have a view, but that view shifts around quite a lot. So I call that the idea of you have a hypothesis, if you want, or you have a view, but you're holding yourself out to yourself deliberately to change. I have nothing at stake if I change. And I change. Now, going in, what's happening is by the time I've read the briefs, and usually I've finished reading them myself, my own process for doing it is I try to read all the briefs for a 2-week argument session. Usually they're 10 to 12. I try to finish them a week or two before the oral argument. I have 4 law clerks. I'll say to the law clerks, you've each read 3 sets. Then I go to them after I've read them and describe a memo. I say, I want you to write this or that, and then you can include other things. Then I read the memo. Then I have another discussion with my clerk. Now I'm ready for the oral argument. All this time, my views are sort of beginning to become more narrow, more tailored. I'll go into oral argument with a view of who's right. And all of us have something like this, that we're pretty much up on the case by the time we're in oral argument, but we're holding ourselves open to be changed. So you want to know how often does it really change? I think 5% is too low. I bet 20% is too high. I mean, it really does matter in a number of cases. Now, a lot higher percentage than that in respect to how I'm looking at this case. Maybe ultimately, basically the same. But the elements of it, what's more important, what's really difficult here, how will it... And those things are very important in a decision. Because the decision will end up being a document of about 10 to 20 pages, and a lot of that document contains statements of the law as it has been interpreted, and people follow it. They have to. So, after the oral argument, I've now gradually sort of coming to rest on this. I'm gradually beginning to get Then we have a day later, usually, or 2 days later, the conference. And I'll go into conference with a fairly clear view, but then I'm listening. And other people listen too. And sometimes people say, oh, well, views never change in conference. But they do. I mean, I've seen it. They do change. People do listen. Now, a lot, will you come out with radically different than what you went in? Probably not. But sometimes, yes. So there's a discussion going on. Then, on the basis of the preliminary views, the Chief Justice, if he's in the majority, or whoever is senior in the majority, assigns an opinion. If it's to me, we all do about the same number over the years. If it's to me, over the year, if it's to me, I then sit down with my clerks. They'll provide an enormously long memo or a draft. I usually start writing something from scratch on my word processor because I'm a former professor and I can't resist my own words. So I'll write a draft, send it back. They'll redo it. I'll rewrite usually twice from scratch. Then, and that's the stage that you were talking about. I mean, that's the stage. Then I've had instances where I just felt, no, this doesn't work, and at that late date I changed. Now, that's hard for a court, because if that happened too often, we couldn't function very well. But it does sometimes happen. Then you circulate. People can write their own. They join. They don't join. Ultimately, everybody has written his own or joined. If I've got 5 on an opinion, I'm very happy. And when everybody writes, it comes out. That's the process.
The President of the United States is in office or took office after a decision of the Supreme Court. So in certain way, the Supreme Court is accountable for the actions of this president.
What's your question?
This president has restricted the rights of the American people, essential rights. Anybody can be accused of being a terrorist. Took away habeas corpus and fundamental rights. My question is this court has a particular duty to be vigilant of this president, has an ethical duty to control his action or not?
The court has a duty under the Constitution to be vigilant of individuals' rights, no matter who's president. And that isn't always such an easy thing. Court, particularly in times of terrorism or war, has made mistakes in the past. The major one being Korematsu, where I think everyone would say that was a mistake, where 80,000 American citizens of Japanese ancestry were brought to camps during World War II and interned in the Midwest. And in 1944, the court upheld that. And the decisions in that case that have lived were the dissenting decisions of Jackson, Murphy, Roberts, I think was the third, right? I think so. And they said this is wrong. There's no evidence. This is a terrible precedent. Well, when we have difficult decisions, the court is not Arthur Goldberg, whom I worked for, and Jackson before him, said the Constitution is not a suicide pact, which means we're fully aware of there are problems of security. Now, that said, it's the basic job of the Supreme Court of the United States to uphold those basic rights and be sure that it can be done. In many instances, they're put in ways of what's reasonable, what isn't reasonable, etc., without repeating what happened in the Revolutionary period just thereafter, where you had the Alien and Sedition Act. You had things at the time of the Civil War, where the writ of habeas corpus was suspended and by the president. And there are many things that occurred that I think today people would say were unfortunate. In the First World War, there were all the scares, the Palmer raids, all those different, a lot of civil liberties cases went to the court. And in World War II, there were cases like that. And I think many of those cases, people today would say were wrongly decided. Well, it's a lot easier to criticize after the event somebody else's wrong decision than to be absolutely certain that you're not making one yourself. So I think that you use the right word. The right word is vigilance. And vigilance, I think, is what's called for by the Constitution in wartime, in peacetime, in any time. That's basically the job of a constitutional judge administering a constitution that gives serious protection to individual rights. So I think we'll do our best.
In case you're too... Go ahead and applaud. Why not? In case you're too tempted to be too cynical about the work of the court, I mean, it is worth remembering that last June, Osama bin Laden's driver sued Donald Rumsfeld, and he won in the Supreme Court. So, I mean, it's a pretty remarkable institution. I mean, there are not many countries, I think, where that might happen. Anyway, last question.
Thank you.
A number of legal scholars, and I believe some of your colleagues on the court, subscribe to the notion of original intent in interpreting the Constitution. Could you tell us your opinion of that notion and where you find yourself on the spectrum that runs from original intent through what you would view as its logical opposite?
May I just interrupt briefly? And could you say a little bit what original intent is? Because I don't think necessarily everybody will know that.
A notion, basically, that you look to the intent of the framers in deciding what the application of the Constitution is today. Is that fair?
That's exactly what I meant.
Yeah. Now, thank you.
Thank you.
So, well, all right. Now, what I think the argument is really about, which is why I put it this way, because as I've just said, it doesn't sound like a bad thing. And in a sense, I would do that too, so would anyone. But I think the argument is actually about, and it's quite a difficult argument, is I think most judges in our court, or most judges applying the Constitution, or any text, a statute, they often face questions where the statute is open, and it's hard to know how these words apply. And in those cases, we have, if I put the matter generically, 6 kinds of tools that I or others will turn to try to answer a difficult textual question, whether of the Constitution or of a statute. First thing always, the text. Second, the history. How did these words get there? Third, the tradition. What kind of legal tradition has grown up around them? 4, the precedent. What do the cases say, this way or that way? 5, the purpose or the value of that particular provision. I mean, the Fourth Amendment is about privacy. That's the value that underlies that, not speech. The speech part of the First Amendment is about free speech, not about privacy. There are values that underlie, or purposes that underlie every text. There's a reason why they're there to accomplish something for human beings who will be affected by these words. And finally, the consequences. The consequences of deciding this way or that way. Which consequences? Consequences relevant to the value or the purpose. Consequences about speech are not particularly relevant if it's a Fourth Amendment case, and vice versa. Now, I think those 6 tools, text, history, tradition, precedent, value or purposes, and consequences are available to every judge, and every judge, one time or another, is going to use them all. Indeed, those who are strongest in favor of original intent are not going to say never use values or purposes or consequences. They'll just say keep away from it as much as you can, because they're afraid the judge will introduce too much subjectivity, his own preferences. There are others, like myself, who say, but I have so many cases where I can't get the answer from the text, the history, the precedent, and so forth. And I think that consequences and values are very helpful. And I know that I'm not there to substitute my values for what was there initially. Initially, under the First Amendment, was a value of protecting speech. And that's the one I'm sworn to uphold. And underlying that Commerce Clause is a desire for a common market throughout the country, not some other thing that I or somebody else could think was better. But to apply them today, I say I have to look to how the Internet works. I have to look to what the consequences will be when we start buying and selling in the world market. It's not just everybody growing his own food now. And so I am tempted and try to write down what I think so it's transparent, but emphasize consequences, purposes, and values, while others the first. So that's something that divides us, and I've written about it, why I think mine works. But maybe I should say one other thing about what holds us together.
Please.
Because Justice Scalia is a strong supporter of the what I call more literal or more literalist approach, and probably a lot of the disagreements I have are with him are sometimes as a result of different starting places and different things. But what I say we all see, and I go back to it because I've already said it, all of us see in the courtroom every single day a courtroom that is there to serve 300 million people who think 900 million different things. And what I like to tell the students, and I sometimes go on, but I won't go on at length in this one, is it isn't always true that that's happened and worked in America. If you go back a couple of hundred years, I pick out cases, and there were cases involving Indians, and there's a case about which Andrew Jackson supposedly said, John Marshall, the Chief Justice, made his decision, now let him enforce it. And he didn't enforce it. Indeed, he evicted the Indians, contrary to the Supreme Court. And many of us have lived through that period of desegregation, and it didn't always just happen. I mean, Eisenhower had to send troops to Little Rock. I mean, you could have had 900 judges as well as just 9 sign Cooper versus Aaron and say, integrate. The paratroopers had to be sent. And I think luckily for us all, he did send them. And there was integration. So when you bring up, as you did, Bush v. Gore, I like to say, and I do say it, I mean it, it is sincere, that the great thing about that case is something hardly anyone notices. Even though I was in dissent, I lost. 5 people decided the opposite. All right, we disagreed. And probably half the country thinks I was right on the right side, another half thinks I was wrong on the wrong side. And they feel strongly on both sides. And despite that, no guns, no paratroopers, no rocks, stones, nothing in the street. They followed it. People followed it. And that is fabulous. See, that underlies, I get emotional about that. That underlies my feeling of what we try to do as a court, of what we try to do as a country, take people who think such different things and help them live together and resolve their disputes peacefully. And I see that every single day going on in the courtroom. And that's why it's such a privilege, I feel, to be there. It's a marvelous thing. Thank you.
Thank you very much.